and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. A warm welcome to each and every one of you. We are on the second to last episode of the Darlie trial. Can you believe it? If you want to catch up from the very beginning, there is an entire playlist on YouTube dedicated to just the Darlie Routier case and her trial. Now, in this episode, what we're going to hear is the state's affidavits in response to Darlie's Writ of Habeas Corpus, which have been covered over the last few episodes. In this episode, you're going to hear from a few of the main players on the prosecution side of the case and the trial. And once again, I'm shooting for October 1st of 2024 to get the next true crime, just individual true crime episode released. So I look forward to that. With that said, let's hear first from Greg Davis, the lead prosecutor in the case. And we begin with the writ affidavit of Greg Davis, who was of course, the lead prosecutor in the Darlie case. And his says, I am an assistant district attorney in the Dallas County District Attorney's Office. I was assigned as lead counsel in the prosecution of State versus Darlie Lynn Routier, cause number, and then it gives the number, and cause number, and again another number, with prosecutors Toby and Sherri Wallace Patton. I have read a copy of Volume 10, pages 1 through 53 of Sandra Halsey's original reporter's record. I have also read Volume 10, pages 1 through 53 of Susan Simmons' red-lined copy of the reporter's record. Volume 10 of the reporter's record covers proceedings in this case that occurred on Monday, October 21st, 1996. I recall that day because that morning, Judge Toll granted the defendant's motion for substitution of counsel and substituted the defendant's retained counsel, Doug Mulder, and his associates for the defendant's appointed counsel. I also remember that day because at the end of the morning proceedings, the judge dismissed the defendant's family members and the press to go to lunch, but the defendant's family members did not return that afternoon. I remember thinking it was interesting that the defendant's family did not return to the trial. I was present during all the morning courtroom proceedings. Volume 10, pages 1 through 53 of Simmons' red-lined reporter's record reflects substantively what occurred that morning. The pertinent pages of Simmons' red-lined record do not contain any material omissions, and it is signed on the 28th of January of 2000. And next up, we have a letter from a Robert Ardis, A-R-D-I-S, who is an attorney at law in Sulphur Springs, Texas. And this letter is to Charles Linch, who was the trace evidence analyst and testified at trial. And it says, Dear Charlie, this letter is to inform you that the applications for writ of habeas corpus will be filed in the Hopkins County Courthouse as of this date for John Miller and Debbie Loveless. We will continue to inform you of any significant happenings. Completion of this task has been a long time in coming for all of us concerned. We hope that the courts will take appropriate actions now and that the case will be dismissed in the not too distant future. And the way that I understand it, just to interject in the middle of this because there is kind of a PS at the bottom of this letter, is that John Miller and Debbie Loveless were at the center of a wrongful conviction in a 1980s Texas case. It was called, I guess, the Loveless-Miller case. And they had been convicted of the murder of their 4-year-old daughter in April. So there's at least some context to that. So anyway, it is signed by Robert and Laura Ardis. And the PS says, you were our first contact in the world outside Hopkins County, other than Daphne, of course. Then you introduced us to Dr. Odom. Then came Dr. Petty, Dr. Clark at the University of Indiana, and Dr. Krause, who is a forensic odontologist, and who introduced us to Dr. Stein, Cook County, Chicago, medical examiner. Dr. Stein is ill, I gather, but has not furnished us with an affidavit, but we have talked to him by telephone, and he is very much interested. And this portion is circled by hand, and it says RE, so regarding the dog bite story. And then there's a notation that says how soon they forget. And it looks like there's initials underneath that, which appear to be CL for Charles Lynch. So anyway, this was admitted into the affidavits for the prosecution. in the writ of habeas corpus for Darlie. So I was a little confused about this and why this letter would have been included into these affidavits for Darlie's case. But the way I understand it is that the reason this letter was included was because, Charles Linch, he was the one who looked at the evidence like the blood and so forth from the Darlie case and had testified for the prosecution. But then they add in this letter that's regarding a totally different case. And the only way that I can think of this properly is that this was likely included just to back up the fact that Lynch knew what he was doing, because it's essentially saying, hey, he also looked at this case and got it right. So that's my thought process on this and why this was even included in the first place. Next up, we have another letter that was actually written from Greg Davis to Mr. Douglas Mulder, who was Darlie's attorney. And this is what it says. It's in regarding to the case and says, Dear Doug, please find enclosed the following. 1. Videotape depicting the injuries sustained by defendant. 2. Videotape of Rest Haven Cemetery taken by Rowlett Police Department on June 14th, 1996. Number 3. Updated transcript of 911 call on June 6th, 1996. And number 4, photographs showing locations of blood samples on defendant's t-shirt. Please be advised that on November 26th, 1996, Officer Charles Hamilton of the Rowlett Police Department lifted 6 latent prints from the boys' upstairs bathroom. They remain unidentified. As always, SWIFS personnel remain ready to talk with you about this case, and in particular about the locations of other blood samples. In addition, the physical evidence remains at the Rowlett Police Department for your inspection. And this was signed by Greg Davis on December 17th of 1996. The next affidavit that we have for the prosecution, or for the state, is from David Nabors. And here's what his affidavit says. My name is David Nabors. I am over 18 years of age, and I am fully competent to make this affidavit. I have personal knowledge of the facts stated herein, and they are all true and correct. I am a lieutenant in the Rowlett Police Department in charge of the Criminal Investigations Division. I am also certified as a senior crime scene analyst by the International Association for Identification. I am qualified to process for and collect latent fingerprints. I have reviewed the affidavit of Darlene Potter attached as an exhibit to Darlie Routier's application for writ of habeas corpus. I have also examined Dalrock Road in Rowlett in an attempt to determine the location of the S-curve Potter describes in her affidavit. Potter appears to be describing one of 3 different locations located at 7609 Dalrock, 8705 Dalrock, and 8900 Dalrock. The 2 aerial photographs attached to this affidavit fairly and accurately depict the roads and straight line distances in question as regards to the 7609 Dalrock and 8705 Dalrock locations. I personally drove from 5801 Eagle Drive to 8900 Dalrock. The driving distance was 2.3 miles to 8900 Dalrock, approximately 2 miles to 8705 Dalrock, and approximately 1.23 miles to 7609 Dalrock. I have also reviewed the claims in Darlie Routier's application for the writ of habeas corpus regarding the knife block and knives collected in the kitchen. I was present when Officer David Main collected the knife block and knives. He stapled the knife block and knives into a paper bag at the scene, and that bag was placed in the property room at the Rowlett Police Department. The knives and knife block had not been fingerprinted when he collected them and sealed them in the bag. I am familiar with the appearance of materials that have been processed for fingerprints, and I would have noticed if the knives had been processed for fingerprints. And it is signed David Nabors on the 7th day of January, 2003. And then it shows some very terrible looking copies of a satellite view of the locations that he's talking about. And I will go ahead and add those like in today's standards from Google Maps so that you can actually have a look at them. If you're watching this on YouTube, you'll be able to actually see them. But if you remember, Darlene Potter was the one who said that she was coming home from visiting her daughter, and she saw 2 men alongside the road. She had been pulling a trailer at that point and had to negotiate an S-curve, so she had to take it very slow. And as she was taking it very slow, she noticed this man for the first man walking outside, and it was around 2 o'clock in the morning. And what struck her was that this man was barefoot. He had on jeans and he was barefoot. And as she goes along this S curve, she sees another man who was a little bit stockier. I believe she said he was shorter. And he began to approach her vehicle. And she saw this man turn around, look at the other man, and the man behind her started shaking his head as if to say no. So that's kind of the correlation there. Okay, I wanted to make note of a couple of things here before we move on because I had to research this, right? This S curve and how far it would have been away wherever Darlene Potter was. So I did what we would normally do in today's world, and I asked Chat GPT. I said, "Here is what this lady said. Given this information based on what she was driving and an approximate location that would be, say, 10 minutes away from 5801 Eagle Drive, where might this put me?" And it did give me an approximate address. Now, if you're looking at it from a satellite point of view, it doesn't really look like probably what you're imagining as an S curve would look like. But according to the information that I received, it said this address on this stretch of Del Rock Road that is north of Highway 66, which is where she said that she was. This particular stretch of road would be difficult to navigate, especially with a full-sized van, which she was driving, and a trailer, which she was pulling behind her, and especially at 2 o'clock in the morning. She even said that she had to put on her brights in order to see in front of her. So I'm going to throw that image up on the YouTube channel so you can actually see it if you're watching us on YouTube. But if not, the address that was closest to where this location would have been is around 7100 Del Rock Road in Rowlett, Texas. Now, this interestingly is next to what's called the Tom Thumb Express, which appears to be a gas station located next to a grocery store. However, that is today, right, in 2024. So I thought, well, how do I know? How would I know if this was even in existence in 1996? And well, luckily they have these photocopies provided in this affidavit, and it does not appear as though this gas station is there, but that grocery store sure is. So to play devil's advocate, if she saw these two men walking down this road and it seemed unusual, she didn't specifically say, I don't think she specifically said which direction they were walking, if they were walking towards Eagle Drive or if they were walking away from Eagle Drive. But, just to play devil's advocate here, I mean, the grocery store parking lot would be a good place to meet, wouldn't it? And I will also be putting up the screenshots or I guess that's what you would call them, screenshots that were included in the affidavit itself, these copies of these satellite images. And then next, right after that, I'm going to put the most recent Google Maps image of what that would look like today based on what they said in the affidavit. So first, we'll have the one that is most logical according to ChatGPT. And then the next few are going to be what was mentioned in this affidavit. Next up in the affidavits, we have one for the state, for the prosecution, from Douglas Parks, who, if you recall, was Darlie's original attorney before he and Huff were replaced by Douglas Mulder and his team. And here's what he has to say. I am currently a criminal defense lawyer in private practice. On June 20th, 1996, Judge Toll, at that time the presiding judge of Criminal District Court Number 3, appointed Wayne Huff and I as trial counsel to represent the defendant in State versus Darlie Lynn Routier. And then he gives the cause number. Judge Toll appointed Blake Withrow as defendant's appellate counsel. On Monday, October 21st, 1996, Judge Toll granted the defendant's motion for substitution of counsel and substituted the defendant's retained counsel Douglas Mulder, Curtis Glover, Richard Mosty, and S. Preston Douglas Jr. for the defendant's appointed counsel. Volume 10 of the Reporter's Record covers the proceedings that occurred on Monday, October 21st, 1996. I was present that morning up until the time that Judge Toll excused me, Wayne Huff, and Blake Withrow. The judge excused us on page 12 of the Reporter's Record. I have read a copy of Volume 10, pages 1 through 12 of Sandra Halsey's original reporter's record. I have also read volume 10, pages 1 through 12 of Susan Simmons' revised reporter's record. I remember that morning, and the pertinent pages of Simmons' record are substantially accurate transcription of the proceeding. Nothing occurred at this proceeding other than what is reflected in the pertinent pages of the Simmons revised record. And this is signed Douglas Parks on the 27th of January, 2000. Next up, we have the affidavit of Robert Poole, and he was or is a firearm and tool mark examiner at the Institute of Forensic Sciences in Dallas, so SWIFS. And here is what he has to say. I am the chief of the Physical Evidence Section of the Southwestern Institute of Forensic Sciences, SWIFS. SWIFS consists of the Dallas County Medical Examiner's Office and the Dallas County Crime Lab. The Crime Lab consists of the Drugs and Toxicology Section and the Physical Evidence Section. The Physical Evidence Section consists of the Latent Impressions, Forensic Biology, Trace Evidence Analysis, and Firearms and Tool Marks. SWIFS and its constituent parts described above are independent entities from the Dallas County District Attorney's Office and the City of Rowlett Police Department. Our function is to provide independent, unbiased scientific services and testimony. Our work for non-county agencies such as the Rowlett Police Department and any others requesting service is on a fee-for-service basis. The Dallas County District Attorney and Rowlett Police Department and anyone else can only request that we perform services. They cannot dictate methods used, nor do they control the outcome of the analysis. They do not have hiring or firing authority over SWIFT's employees or even input into those decisions. This was true in 1996, and it is true today. And this is dated December 18th of 2002. Next up, we have one of two affidavits from Toby Shook, and he was the assistant to Greg Davis and the assistant district attorney, Dallas County, Texas. And here is what he has to say. I am an assistant district attorney in the Dallas County District Attorney's Office. I was assigned to assist in the prosecution of State versus Darlie Routier, and then again they give the cause number for Dallas County and the cause number for Kerr County, where the trial occurred, with prosecutors Greg Davis and Sherri Wallace Patton. I have read a copy of Volume 10, pages 1 through 53 of Sandra Halsey's original reporter's record. I have also read Volume 10, pages 1 through 53 of Susan Simmons' redlined reporter's record. Volume 10 of the reporter's record covers proceedings in this case that occurred on Monday, October 21st, 1996. I specifically remember that day because it was the first day of this capital murder trial, which was held in Kerrville, Texas. I also remember that day because that morning, Judge Toll granted the defendant's motion for substitution of counsel and substituted the defendant's retained counsel, Doug Mulder and his associates, for the defendant's appointed counsel. I was present during all the morning courtroom proceedings. Volume 10, pages 1 through 53 of Susan Simmons' redlined reporter's record is a substantively accurate representation of what occurred that morning. Nothing material is omitted from the pertinent pages of Simmons' corrected version. And this was done on January 28th of 2000. And here is the second affidavit, also by Toby Shook. And aside from the same information about the trial court numbers and everything like that, he goes on. Charles Linch, formerly a trace evidence analyst with the Southwestern Institute of Forensic Sciences, SWIFS, in Dallas, Texas, testified in the state's case in chief in the Routier case. I understand that Routier's state writ attorneys have alleged that I had, quote, direct knowledge of Lynch's mental health problems, unquote, as well as, quote, direct knowledge of his hospitalization for alcoholism and depression, unquote. The basis for this allegation is an article that appeared in the Dallas Morning News newspaper on May 7th, 2000, which provides in part, and they go on to quote, Dallas County Assistant District Attorney Toby Shook, Mr. Linch said, had a friend at Doctor's Hospital who told him about his hospitalization, and the prosecutor asked Mr. Linch about it one day at the courthouse. Mr. Shook, the prosecutor, who had relied heavily on Mr. Lynch's testimony in the Albright case and would later use him in the Routier trial, said he believed the forensic expert had been treated for alcoholism and only recently learned that he had been hospitalized for depression, too. And then there's a quote within this, quote, As far as people's personal business, yeah, I think that it was no secret that Charlie had some drinking problems, unquote, Mr. Shook said, end quote. That was what I was aware of. That was always on his own personal time, unquote. And then the affidavit continues. What follows is a more detailed and accurate explanation. And he goes on. In the early 1990s, I ran into a friend of mine who knew I worked at the district attorney's office. She told me she had met another friend of mine, Charlie Linch, while they had both been in the hospital together. She explained what a great guy she thought Linch was, and I agreed. I did not know why she or Linch had been in the hospital, and I did not ask. A few weeks later, I saw Linch at the courthouse. I told him that I had seen a friend of mine who said she had met him in the hospital. Linch looked surprised, but did not elaborate. I never asked Linch why he had been in the hospital, and he never volunteered any information. Sometime after the Routier trial, I learned that my friend, who told me about being hospitalized with Linch, was being treated for a drinking problem. It was then that I speculated that she and Linch must have been hospitalized for the same reason. I had heard from time to time that Linch sometimes drank a lot outside of work, but I never had personal knowledge of this. I have never heard or seen any evidence that his drinking interfered with or affected his work in any way, and no one has ever told me that Linch had a drinking problem that interfered with his work. To my knowledge, Linch has always performed exemplary work as a forensic scientist, and he has been and continues to be well respected in the community, as well as both inside and outside the state, for his technical skills and expertise. In fact, throughout the years that I've known Linch, I have never observed him under the influence of alcohol, at the courthouse, or while working. I was not aware of any allegations that Linch suffered from depression or that he had been admitted to the psychiatric unit of a hospital until newspaper reporters began investigating Lynch's background for the newspaper articles. I have never heard about or even seen evidence that depression interfered with Lynch's work in any way while he was at SWIFS. I have worked on several cases with Linch over the years, and I have always found him to be objective and his opinions scientifically based, and he never seemed motivated by a particular result for one side or the other. As a forensic expert and a consummate professional, Linch would simply test the evidence and report the results. Shook then moves to a different point, and this is point number 2, which says, in preparing for the Routier trial, the state hired psychiatrist Dr. Kenneth Dekleva as a consultant. At that time, we anticipated that the defense would be calling a psychiatrist or psychologist during trial to talk about traumatic amnesia. We later learned that the defense would, in fact, be using Dr. Lisa Clayton as one of their experts. In preparing for Dr. Clayton's testimony, we consulted Dr. Dekleva often about traumatic amnesia questions we could use to cross-examine Dr. Clayton and about possible rebuttal testimony. At some point, Dr. Dekleva and I also discussed punishment issues, although we did not know at that time whether the defense would call a psychiatrist during the punishment phase. I personally selected the jury in Kerrville, and from questioning the jurors and reading their questionnaires, I did not feel that they were going to put a whole lot of stock in psychiatric testimony. In fact, Dr. Dekleva did not go to Kerrville for the trial, and therefore he did not hear any of the trial testimony. In discussing punishment issues, Dr. Dekleva and I went over what he called various risk factors involving Darlie Routier. It is common in every case in which Dr. Dekleva has acted as a consultant for the Dallas County District Attorney's Office for us to discuss risk factors that would weigh for or against a defendant's future dangerousness. In Mrs. Routier's case, Dr. Dekleva indicated that risk factors showing her to be dangerous were, obviously, the brutality of the crime, her lack of remorse, and the innocence of the victims she had chosen. As far as risk factors that were in her favor, i.e., she would not be violent, Dr. Dekleva said that there was no evidence of her being violent while in jail awaiting trial. It should be noted, however, that any time a capital murder defendant has not had discipline problems in jail, the psychiatrist must always say under oath that that is a factor that weighs in the defendant's favor. It should be further noted that this is an obvious factor considered in any case, whether there is an expert involved or not. At no time did I ever tell Dr. Dekleva we were not calling him because he had an opinion that Mrs. Routier would not be violent in prison. In fact, Dr. Dekleva never expressed an opinion on the ultimate issue of whether Ms. Routier would constitute a future danger to society. During the punishment phase, I told Dr. Dekleva we would not be calling him for several reasons. One, we did not need a psychiatrist because, after viewing the jury during jury selection and reading their questionnaires, I thought they would be required to answer the special issues the way we wanted. Two, the jury seemed tired and ready to make their decision, and they had plenty of evidence to base it on. The state believed that the jury's finding of guilt and the overwhelming evidence we had of the defendant's vicious crime was sufficient for them to answer the special issue number one, yes. Also, the defense did not call a psychiatrist in the punishment phase, so there was nothing to rebut from a scientific point of view. These were the reasons Dr. Dekleva was not called. And it is signed Toby Shook on January 7th of 2003. Next up, we have a very short affidavit from Susan Simmons. And if you recall, she is the one who redid the trial transcripts because the original court reporters were so bad. A judge had essentially had somebody else do them. And so this is the affidavit of Susan Simmons, who redid the trial transcripts. Stephen Cooper drafted the affidavit that I signed on August 20th, 2002. To the extent the affidavit suggests that Sandra Halsey's stenographic notes from the trial of Darlie Routier are unreliable, untrustworthy, or inaccurate, it is not correct. Rather, Halsey's notes are incomplete in places due to misstrokes and other occurrences that might normally occur during trial and can be made complete by listening to the audio tapes. I stand by my courtroom testimony that the problem with the Halsey record was one of editing, not recording. If Halsey had proofread the transcript she received from her scopist, Halsey's record would look like mine. And it is signed by Susan Simmons on January 6th of 2003. The next piece in this set of affidavits is kind of interesting. I'm taking a look at it here. I have not seen this before. And what it is it is an interoffice memo. It is from the Southwestern Institute of Forensic Sciences at Dallas, so SWIFS, and it says to Dr. Jeffrey J. Bernard, Director, from Robert Poole, Chief Physical Evidence Section. It's dated August 6th of 1999, and the subject is Civil Service Hearing, Grievance filed by Charles Linch. And here's what it says. After learning this week of Mr. Lynch's request for a civil service hearing that is dated March 29th, 1999, I find myself puzzled about how to respond. Mr. Linch not being selected for promotion is not based on any lack of technical skills, but rather his inability or unwillingness to work cooperatively with other staff members or supervisors. This performance problem did not begin with me. Mr. Linch has a history of being unhappy with the goals and direction of this organization that well predates my becoming a supervisor. His resignations and re-employment should be adequate to substantiate his dissatisfaction. The fact that he was rehired, despite these problems, evidences his technical expertise. There should be documentation within the institute or at the personnel department to support that. From comments he has made over the years, it is my opinion that he continues to be bothered by the disparity between his grade, FM, and the other forensic scientists in the physical evidence section, GM, even though his actual salary exceeds that of many of the GM staff. One of my first exposures to Mr. Lynch's communication and work practices came in early March 1998, just days after I was promoted to chief of the physical evidence section. Mr. Linch, as you may remember, was splitting his time between the mitochondrial DNA, mtDNA, project and his trace evidence responsibilities. One of his roles in the trace evidence unit for many years was the evaluation of crime scenes. He had been called upon on numerous occasions to interpret blood spatter at violent scenes. He had testified as an expert witness. It was about that time we were beginning in earnest our pursuit toward laboratory accreditation. One of the requirements, as you know, is the participation in proficiency testing, and the county had purchased a blood spatter proficiency test. I gave the test to Dr. Timothy Slider, the serology/DNA unit supervisor, and told him to have Mr. Lynch and two other analysts take it. To my surprise, Dr. Slider came to me and said that Mr. Linch, quote, didn't want to take it, unquote. He provided me with a copy of his memorandum to Mr. Linch and the others. On it was a handwritten entry from Mr. Linch. I discussed this with Mr. Linch. Despite his having testified as an expert on blood spatter, he alleged that his lack of formal training in this subspecialty should preclude him from taking the test. I might point out that formal training was conducted here in the Institute and Mr. Linch did not participate. Inasmuch as there were 2 other trained analysts, I acquiesced and Mr. Linch did not take the test. I did, however, explicitly instruct Mr. Linch not to be involved in requests of this type in the future and to transfer any such requests to the other 2 analysts. As enclosure 1, I have attached a copy of memoranda from Dr. Slitter to me and his memorandum to Mr. Linch and the others. I have taken the liberty to highlight what I think are key points and/or phrases. A second example of Mr. Lynch's failure to work cooperatively with department supervision also came in March 1998, again, just shortly after I was given my position. He sent me a memorandum that was affixed to a memorandum he had written to Dr. Stone a couple of months earlier, complaining about his role in the Institute. I have attached a copy of both and annotated them as enclosure 2. In his memorandum to Dr. Stone, he was questioning his being a grade FM given the additional duties he had in the mtDNA. I viewed his memorandum to me as dictating what his priorities and responsibilities would be. You may recall that at that time, Mr. Linch was one of 2 trace evidence analysts who specialized in hair and fiber examinations. The other examiner, Miss Stephanie Smith, had applied for a position with the U.S. Postal Service Crime Laboratory and was waiting for a reply. Her departure was imminent. As the supervisor responsible for the operation of that unit, it was my responsibility to ensure that we maintained hair and fiber analysis capability. I conveyed that to Mr. Linch and told him that I did not have the luxury of allowing him to devote all of his energies to the mtDNA, especially with Miss Smith leaving. I have taken the liberty to highlight some key phrases on those memoranda that, in my opinion, point to Mr. Lynch's poor communication practices. My next encounter with Mr. Linch came in the following month, April 1998. Again, it involved proficiency testing, this time in the analysis of fibers. In yet another memorandum to Dr. Slitter, Mr. Linch expresses his lack of confidence in what he titled, quote, value placed on infrequent, inadequate manufactured proficiency testing, CTT, versus real-world casework testing, unquote. My opinion differed, of course, and I insisted Mr. Linch took the test. I have attached, as enclosure 3, the 2 memoranda. In his memorandum, contained in enclosure 3, Mr. Linch actually boasts of his expertise in fiber examinations, exemplified by having his work scrutinized by numerous other experts. Even though he took the fiber proficiency test, this issue did not go away. Instead, Mr. Linch responded to Dr. Slitter with another memorandum insinuating he lacked adequate training in fiber analysis. I met with Mr. Linch to discuss this issue. Mr. Linch told me he lacked sufficient training to confidently perform certain types of instrumental analyses on fibers that were now required. I had no option but to suspend his involvement in fiber analysis until I could establish his level of competency using a formal, recognized methodology. I did this despite my opinion that his competency had been sufficiently established through the training he had and the peer review process. My memorandum to him, formally suspending him from fiber analyses, was returned to me with another handwritten entry suggesting that he be suspended from doing hair analysis as well. I have attached those 2 memoranda as enclosure 4. Dr. Slitter and I met with Mr. Linch on May 13, 1998, to discuss his responsibilities in the physical evidence section, reiterating his functions as outlined in Dr. Slitter's memo that's in enclosure 4. It was during this conversation, with an understanding that I could not afford to take him completely off of hair and fiber analysis if cases came in that needed to be worked, that I asked Mr. Linch to consider whether or not he wanted to continue participation in the mtDNA project. In his memorandum to me the following day, Mr. Linch opted to, quote, return to my paid status as a full-time hair and fiber microscopic examiner, unquote. I have attached his memorandum as enclosure 5. The next significant event for which I have documentation comes in September 1998. I was at that time the commissioners in their September 15th, 1998 letter to all elected officials and department heads announced the fiscal year 99 salary adjustments. As is normal practice, all Institute employees were given a copy of that letter. A day or two later, following its distribution, I found a copy of that letter posted on our common bulletin board with a handwritten annotation. It clearly is Mr. Lynch's writing and speaks for itself. I immediately removed it from public view, but by the time I saw it, I suspect most others would have seen it. I have attached it as enclosure 6. Some few days later, apparently dissatisfied with the manner in which the court distributed the adjustments, Mr. Lynch sent me a memorandum asking for permission to write to the court. My reply is dated September 29th, and I have attached a copy as enclosure 7. I do not know whether or not he communicated with the court. I believe this is also the time frame in which he bypassed the Institute chain of command and complained to the personnel department about his grade structure. I do not have copies of any of that documentation. On October 1st, 1998, just 2 days after my memo to him about communicating to the court, I happened to be in the trace evidence unit. Affixed to the door of the hair and fiber section of the trace evidence unit was what I considered to be an inappropriate sign. It bears Mr. Lynch's handwriting and was on the door leading into his work area. I removed it and returned it to him with a memorandum. I have attached those documents as enclosure 8. In the latter part of November 1998, I met with each employee individually and discussed with them their individual performance and how it related to the section and institute's goals. As a template, I used the county's performance appraisal form and discussed each item with every employee. Mr. Lynch was not excluded from these one-on-one sessions. I took that time to counsel Mr. Lynch on his interpersonal relationships with both his coworkers and his superiors. I specifically mentioned that I hoped for an improvement in his relationship with me. I was clear to point out that this part of his performance needed adjustment. This brings us to December of 1998. On the 7th, Mr. Lynch gave me a handwritten memo complaining about the use of phenyl/chloroform in the trace evidence unit. This process was part of the mtDNA work, and as far as I knew, it had been going on for months. What gave me the most concern was his use of the word, quote, illegal, unquote, in describing what was going on. I think my actions, as reflected in my memorandum for record, following his notifying me, were swift and thorough. It and other supporting documents are attached as enclosure 9. I vehemently disagree with the sentence in his, quote, request for grievance appeal to Civil Service Commission, unquote, in which he states, quote, no action taken to solve the problem, unquote. I did take the opportunity, after having corrected what everyone agrees was an inappropriate procedure, to once again counsel Mr. Lynch on his interactions with others in the laboratory. On December 9th, Mr. Lynch filed a county, quote, employee's report of accident form, unquote. I would like to make it clear by restating that at no time during our discussions, no time prior to his submitting the accident form, did Mr. Lynch ever hint that there was an injury associated with this incident. After receiving his form, and in accordance with county policy, I initiated an immediate investigation and completed a, quote, supervisor's accident investigation report, unquote. Mr. Lynch declined to seek follow-up medical attention. In my superior's report, I do comment on the timing between my second counseling of him and his filing of the accident form. It is my understanding that this accident packet was forwarded to the personnel department for review. I have attached this packet of documents for thoroughness and have marked them enclosure 10. On December 7th, Mr. Lynch sent me a memorandum asking to have his work hours adjusted in order to take a college statistical course. I am aware that formal statistical classwork is required of our DNA analysts, but since Mr. Lynch had removed himself from that arena, I was unclear how this might apply to trace evidence. I wrote 2 memos to Mr. Lynch, both dated December 9th. The first was my asking for additional information about how his taking a course would benefit the institute or the county. The second one was my final decision. Mr. Lynch, in replying to my need for additional information, centered his justification on the reliability, or lack thereof, of microscopic hair comparisons. I find it interesting that in his, quote, request for grievance appeal to civil service, unquote, He mentions numerous trace evidence subspecialties that use statistics. Hers is not one of them. I have attached this packet as enclosure 11. It was during this same time frame that I began trying to assess revenue and casework productivity trends in the trace evidence unit. There was no pattern that I could get a handle on. I had noticed that on occasion, when I would walk into the trace evidence unit, Mr. Linch would be absent from his work area. When I'd ask where he was, I would get answers like, he's gone downstairs, or he's gone over to the library. As you know, it was during this time that Miss Vicky Hall began her FMLA to give birth to her first child. With her and Miss Angie Brown's departure, the staff in the trace unit was cut in half. I wanted to get a handle on how the two remaining people, Mr. Linch and Mr. James Adams, were spending their time and whether or not it was being used sufficiently. The instrument I chose to try and become more quote-unquote supervisory was to have Mr. Linch and Mr. James Adams keep a daily log of their casework-related activities. Mr. Lynch's statement in his, quote, request for grievance appeal to civil service commissions is false. Both complied with the assignment. After the first month, I recognized that not being an expert in this discipline, there was little I could detect in their daily logs. I did not tell them to stop, but it was not consequential to me that Mr. Adams stopped giving them to me in January. Eventually, Mr. Linch stopped as well. Because of his frequent absences from his work area, I did ask Mr. Linch to let me know when he left our floor. Mr. Linch alleges that he was the recipient of a, quote, demeaning memo, unquote, when the daily log wasn't filled out properly. I have attached as enclosure 12. His first log, along with a copy of the memo I gave him the following day. I think any supervisor would come to the same conclusion I did. I do not consider any of the language in it to be demeaning. I did, once again, take the opportunity to give him a chance to improve his performance. Mr. Linch has said that I denied him the opportunity to lecture on mtDNA when he had done so on a previous occasion. I would like to point out that when he gave the lecture to which he refers in April 1998, he was fully involved in the mtDNA project. After his personal decision to opt out of that process, in May 1998, he began making disparaging comments about the lack of progress in bringing this technology online. He was not supportive, nor did he seem to have any understanding of the challenges faced by Dr. Slitter in trying to juggle this project with all the other activities going on in the forensic biology unit. I did not feel Mr. Linch was the right person to represent the Institute in this matter. I asked him to provide me with a point of contact so that the Institute could provide a qualified lecturer. He did not. I can only conclude that his interest in lecturing to this group of attorneys was for personal reasons and not an interest in their being given information on the potential for this new technology. In summary, let me say that this is Mr. Lynch's second or third grievance of something I've done, or in this case, something I did not do. Like the others, this one is completely without merit. With regard to this latest one, I can say there was no restraint, nor were there any reprisals. My decision to select Mr. David Spence was one I made given what I thought were in the best interest of the physical evidence section, the Institute, and Dallas County. I think there is abundant information to indicate Mr. Linch has not displayed any potential to competently perform supervisory functions, rather the contrary. I did consider Mr. Linch for the position, along with the other applicants qualified by personnel for the senior trace evidence position. However, I believe Mr. Linch is well aware of his performance and is looking to shift blame for his own, very often inexcusable conduct. And that's where it ends. They do not within this document have these attachments that he refers to in this memo. So before we move on to the next affidavit, I just kind of wanted to interject here a little bit. This is definitely a very eye-opening look at Mr. Linch, right? The entire time I was reading this, I thought two things. One, if he was rarely in his office and had the time to complete so many memos complaining about different things, how in the world did he get any work done? You know, obviously he did finish something, or he wouldn't have had a lot to say at trial. But then you have to wonder just how thorough he actually was. And second, his boss, seriously, is a saint to have to deal with an employee like this who appears to have one objective, and that's to make your work life a living hell. He treats it with Tons of professionalism. I was very, very impressed with this. And next, we move on to the affidavit of Sherri Wallace. And there's only two more affidavits for the state's writ exhibits, excuse me, after this one. So it continues. It says, "My name is Sherri Wallace Patton. I am over 18 years of age. I am fully competent to make this affidavit. While employed as an assistant district attorney for Dallas County, I was assigned to prosecute the state versus Darlie Routier case." And then, of course, gives the numbers for Dallas County and Kerr County. And then she goes on with prosecutors Toby and Greg Davis. "At the state's request, I read a copy of Volume 10, pages 1 through 53 of Sandra Halsey's original reporter's record. I also read Volume 10, pages 1 through 53 of Susan Simmons' revised reporter's record. Volume 10 of the reporter's record covers the proceedings in this case that occurred on Monday, October 21st, 1996. I remember the events of that morning. I was present during all the morning courtroom proceedings, except toward the end of Judge Toll's general voir dire to the jury panel, when I went either to the back of the courtroom or just outside the courtroom to get the juror questionnaires. My momentary absence is reflected on page 46 of the reporter's record. Volume 10, pages 1 through 53 of Susan Simmons' revised reporter's record is a substantively accurate rendition of what happened that morning. The pertinent pages of Simmons' revised record do not contain any material omissions." And it is signed Sherri Wallace Patton on January 27th, 2000. And next up, we have it's the same person, but two affidavits from the same person. And these are the last two affidavits for the state. And I believe, so this one is done by Pat Wertheim, is I believe how you pronounce the last name. And he was the one who provided this affidavit to the state saying that and it's about the fingerprint 85J, saying that the methods used by Jantz, who we heard from in the previous episode regarding the defense affidavits, was quote unquote misleading and unreliable. And I believe that one of the defendants or the defense writs by Jantz actually addresses this particular statement. I'm pretty sure that's the case. But anyway, let's listen to the affidavit of Patrick Wertheim and part one. And he continues. He goes, "I am a criminalist 4 with the South Region Crime Laboratory, Arizona Department of Public Safety in Tucson, Arizona. My job assignment is, quote, latent print examiner, unquote. In this capacity, I undertook the analysis of the following: States Exhibit 85I and 85J from the case styled The State of Texas versus Darlie Routier, a report of anthropological analysis. In the case by Richard L. Jantz, Ph.D., and excerpts from writ filed in the case. My report of this analysis and a copy of my current curriculum vitae are attached to this affidavit and incorporated herein. And this is signed January 3rd of 2003. So in his continuation of this, we're still in part one of Wertheim's report. It's actually 13 pages long. There's a lot of technical and detailed information here, but I'm going to read the certain points that would be, I believe, of interest. I mean, I highly doubt that you want to hear about the what fingerprint identification is and what dermatoglyphics is. So we'll get kind of into the heart of this. And this says in point number 4, the Jantz report considers the fingerprints of Damon and Devin Routier, the murder victims in this case, and presents probabilities for the characteristics of the boys' fingerprints within ranges for children and for probabilities regarding the characteristics of the latent fingerprint in relation to ranges for both children and adults. In the paragraph at the top of page 4 of the report, Dr. Jantz summarizes these probabilities as roughly 75% each. That is to say, the boys' fingerprints are about 75% within the accepted range for children their age, and the latent print is about 75% within the accepted range for adults. Although Dr. Jantz does not explain the meaning of these probabilities, one interpretation might be that the two boys' fingerprints extended outside the range for children their age, and the latent print extends below the range for adults. Do these areas overlap? Dr. Jantz doesn't say, and we don't know. Number 5. In both of the excerpts of the Writ of Habeas Corpus, The defense misrepresents James Cron's testimony. In the quoted testimony, Cron states that he, quote, couldn't make any identification, unquote, and mentions, in response to a later question, that the prints, quote, lacked sufficient points of identification, unquote, for him to make an identification. Further, he says only that the print, quote unquote, could be that of a juvenile and that, quote unquote, it's possible the print might be that of a 5 or 6-year-old child. The defense represents this as, quote, glaring misinformation, unquote. It is not glaring misinformation at all. It is simply a factual statement that based on sufficient points of identification, as Cron put it, he did not make an identification, combined with a not inaccurate subjective generalization of the size of the latent prints and its ridges without regard to any specific individual. In both of the excerpts of the Writ of Habeas Corpus, the defense also misrepresents the Jantz report. In his final conclusion, Dr. Jantz states that probabilities range from 0.767 to 0.985 that the latent print in 85I and 85J was made by an adult. The defense states, quote, contrary to Cron's testimony predicated on his abilities, the latent fingerprint had sufficient points of identification for University of Tennessee professor Richard Jantz to conduct an anthropological analysis of the fingerprint, unquote. In the first place, that is comparing apples to oranges. Cron is a fingerprint expert, not an anthropologist. Jantz is an anthropologist, not a fingerprint expert. Cron based his comments on his training and experience. Dr. Jantz based his reports on published dermatoglyphic tables with limited experimentation. Second, Jantz based his conclusion on ridge width, number of ridges per centimeter, and crease to core distance, not points of identification. Points of identification, ending ridges, bifurcations, and dots played no role whatsoever in Dr. Jantz's analysis. The terms points of identification or points never once appear in his report, nor does he even make reference to the concept of points of identification. Quote, ridge width, unquote, and, quote, area between pattern and flexion crease, unquote, are distinct and separate concepts and are as completely unrelated to points of identification as apples are to oranges. Point 7. In both of the excerpts of the Writ of Habeas Corpus, the defense also misrepresents the Jantz report in another way. The defense states that, quote, Jantz concluded the latent fingerprint belongs to an adult, not a child, unquote. Jantz never makes such an unequivocal statement. He presents a range of probability that, at its lowest, gives a roughly 3 in 4 chance that a latent was made by an adult, which might be construed as implying that there is a 1 in 4 chance that the print was made by a child. Point number 8. Regardless of the statistical logic of Dr. Jantz's analysis, his conclusion falls outside the accepted conclusions of fingerprint identification and is misleading in its application. The use of measurements of general attributes in small area of a smudged, bloody, latent print is not in this case a sound basis to include or exclude a specific individual as being the donor of, i.e., as having made that specific latent print. 9. The Jantz report does not explain the statistical methodology used to derive the reported probabilities. Worse, the Jantz report mixes 2 different methods of representing probabilities. In some places, the report refers to percentage probabilities. In other places, it refers to probabilities as a decimal fraction of 1.0. This leads to the suspicion that different methods were used to calculate different probabilities. And if you recall, I'm going to interrupt here. If you recall, when we heard the Jantz report within the defense the defense affidavits, he specifically does address this and kind of in a backhanded way. He's like, well, percentages and decimals are the same, and even gives the way to calculate them, which I thought was a little funny. But anyhow, he responds to this report. In the end, this Patrick Wertheim says, in summary, I find that the Jantz report presents a misleading and unreliable conclusion, but that James Cron's earlier testimony was accurate. Then we move on to his second affidavit, which is much shorter. And this one is dated January 6th of 2003. And he goes on to say that he is, again, says, I'm a criminalist 4 with the South Region Crime Laboratory in Arizona. and that his job assignment is latent print examiner. And then he talks about how he undertook an examination of the following state's exhibits, 85I and 85J, from the state of Texas versus Darlie Routier. And then he goes on to list all of the known fingerprints that he has on file. And I'll just read through these once because they're mentioned multiple times throughout this document, even though it's much shorter. And it says, and the known fingerprints of Rodney McGaffey, Simon Johnson, Darren Routier, Darlie Routier, Thomas Ward, Catherine Long, Charles Linch, David Waddell, Larry Byford, Todd Higgins, Rick Coleman, Michael Youngblood, Dennis Vrana, Brian Koshak, Jack Colby, Eric Zimmerman, Dwayne Bedingfield, Charles Hamilton, Bobby Clark, Lamar Evans, Chris Frosch, James Patterson, David Main, Charles Hamilton, David Waddell, David Nabors, James Walling, and Dana Stahl. And then he goes on to say that his report is attached. And essentially he went through and used the 85I and 85J and compared them to all of these folks. And at the very bottom says, in summary, all of the people whose fingerprints were compared were excluded as the source of 85J except Darlie Routier. She could neither be excluded nor identified. All right, so let's recap what we've heard a little bit. First of all, the state's affidavits, they mainly center on the portion of the trial transcripts that couldn't be verified because there wasn't an audio tape to use to compare that to what the original court reporter had written in her transcripts. And this is the area or the section where Mulder had replaced Darlie's original attorney, Doug Parks. We also heard about Charles Lynch's erratic behavior in the workplace. And you've already heard my thoughts on this in the memo affidavit of Robert Poole, who was Lynch's supervisor. And additionally, we then heard from a fingerprint guy about how the work that Jantz did, and Jantz gave his affidavit in the previous episode for the defense. But anyway, we heard about the work that Jantz did and how this fingerprint guy didn't think it was nearly the same because Jantz was an anthropologist and not a fingerprint specialist and so forth. But the most interesting, in my opinion, was the affidavit of David Nabors, where he tries to pick apart the testimony of Darlene Potter, who was the one who happened to be driving along Dalrock Road and noticed two men. And you've heard my thoughts on this as well in his affidavit. All in all, the state's affidavits, they didn't really offer anything that I would consider explosive, unlike the affidavits that were included with the defense's writ in the previous episode. And my next episode, I was originally going to talk about the notes that Darlie's Aunt Sandy had taken while in the courtroom during Darlie's trial. She's been brought up just a couple of times, and maybe you don't recall who she was, but she sat in the audience during Darlie's entire trial and took notes about just about everything. Now, the small newspaper snippet that I was going to refer to, after going through it, it doesn't really give a whole lot of information aside from this, and this was interesting. She noted, I believe, that it was 18 times that the judge appeared to be sleeping. So aside from that, I have one episode left of the Darlie trial transcripts. This whole case has been a very long and interesting journey, hasn't it? This next episode, though, is going to be a little different. I'm going to give you some updates of the key players. I'm also going to give you some information about what's happened since the trial, including where the DNA test results are at this point in time, and give you my personal opinion on whether or not I feel that Darlie is guilty or not. Now, this episode will be released on Tuesday, September 17th, 2024. So, to be sure that you get notified, be sure that you are subscribed to the podcast. And if you're on YouTube, click the bell so that YouTube knows to notify you as soon as it goes live. Thank you so much for listening. We will talk very soon. Bye for now.